I'm not going to do this and I'm not going to do that. And it was just, it was, I never thought that it would actually be about the money as far as me spending time with my son, you know.
Johnson and Bourgeois. We just did an order on this case back in May, and 5 months later, there's a new modification. So, and that May order became final, and so obviously, I'm looking at a 5 month difference, and appears that the modification is a request for modification of child support within 5 months. Is that it?
That's it, Your Honor. The basically what we're going to we had some pretty serious misunderstanding, but we were outside the 90 days to file a motion for new trial. I think Ms. Johnson misunderstood the questions I was asking. There's money from the Department of Defense, but it's not. I think it was reported to the court that the money was getting paid directly to Ms. Johnson. That was incorrect. It was going through the state disbursement unit, and so arguably the deviation was based on misinformation.
I'm not sure. Okay, I'll let you explain that to me, because if it was just because it wasn't going to her directly, but going through the state disbursement unit, it sounded like it still should be getting to her. So, all right, let's get this on the record, and I'll let you explain to me why the court has yours, because again, I can't go behind that original order, Mr. Diamond. I can only go for what's since that original order. So it is what it is. So here we go.
State's requesting a modification. This would have been a motion for new trial if we'd caught it sooner. But there was significant misunderstanding, I believe, in communication between the state and Ms. Johnson. So we own that, Your Honor. My understanding, the correct facts, which were not presented to the court at the time, were that Ms. Johnson receives $913 in direct benefits as a result of Mr. Bourgeois' disability. And by the way, Your Honor, if I can advise the court that, as I understand it, Mr. Bourgeois is with his brother in the hospital. His brother is stage 4, and so that may be an issue if something comes up. But I want to make the court aware of that. But he was nice enough to call in today. The $913 is.
Okay, go ahead. Tell me what that's direct benefits from. Thank you.
So $913 as a result of his disability. I believe that's through Social Security. However, there's an additional $497 that it was coming from his, I believe it's his Army retirement. Miss Johnson, I think mistakenly, or we misunderstood that the money was not going directly to Miss Johnson. It was going to the state disbursement unit who was dispersing to Miss Johnson. So the court ordered a deviation down to 0 based on the court thought that she was getting $913 from the disability, $497 from the Army. The difference was $60. And I understand, Ms. Johnson, I know it's wrong. That's what I told the court. He was wrong. So the difference would have been $60. And back then, Ms. Johnson agreed to take a child support at 0. I'll let her tell the court why. I think she's no longer wanting to do that either. But the state is asking that the child support be set at $497, which gives Mr. Bourgeois the credit for the $913 that is going directly to Ms. Johnson.
All right, and the $497 that you thought was going directly to her or was going through the state disbursement unit, is that coming in any manner, way, shape, or form, Mr. Diamond?
No, it's been cut off as a result of this incorrect order, Your Honor. The Army saw that and they cut it off. I'd say the Army, the Department of Defense.
Okay.
Or actually, my agency sent them something. I'm sorry, I'm not trying to take a tone with the court. My agency sent something to the Department of Defense saying child support is 0, so quit sending the money, which the Department of Defense.
Okay, I got how this happened. All right then.
Yeah.
All right. Okay. And based on the findings that the father was supposed to pay the difference between the Social Security disability and the amounts that were and the money that he should have been paid based on his actual income, he was given credit for that, but somehow the Army took that to, hey, we don't have to pay that anymore. That shouldn't come in, and cut it off, even though the court order last time says that it is included in the child support amount and should be included in the child support amount. All right, got it. All right. All right, obviously that's a clerical thing, not a technical change in the amount of child support. So I think we can do something with that one way or the others. So let's go ahead. I'll let you finish up your opening, and then I'll swear the parties in, and we'll take it from there. Thank you.
Thank you, Your Honor. And then I believe Mr. Bourgeois' request to the court is going to be for a downward deviation. I think his testimony will be he's a permanently disabled combat veteran. Yeah, I know that he's active with I think horses as part of therapy, and I think he involves their child with that. And I think he'll testify to the strain that being made to pay that additional amount would cause. But I'll let Mr. Bourgeois tell the court why a downward deviation would be appropriate. I think, yeah, and that's the short version, Your Honor.
All right then, folks. Let me swear y'all in, and let's see where we're going to go on this one. So at this time, Ms. Johnson and Mr. Bourgeois, how you pronounce that, sir? The last name again, please.
You said it right, Judge Bourgeois. You said it right.
Okay.
Yes, sir.
Yeah, I hate that's sometimes that term is used as a as a slight, and I don't want to make sure I wasn't trying to slight you, sir. But anyway, I'm going to go ahead.
I deal with him in the military enough.
I bet. No truth and nothing but the truth to help you.
I do.
All right, you're both officially. Do you so swear, sir?
Roger, Judge.
All right, you're both officially on the oath, and I'll go ahead and let the state call your witnesses. Thank you.
Thank you, Your Honor. Call Ms. Johnson. Ms. Johnson, did my summation to the court, did that, well, let me say it this way. You heard what I told the court. Is there anything that needs to be corrected or clarified?
So back in May 16th of this year, we went to court for a modification of the child support amount. We spent about a year because I filed the request.
Okay, ma'am, you're getting ready to go into a long narrative, a long story with the state. You need to just listen to the question and answer the question. I understand what we did, and I think I understand how it all happened. But again, the state will cherry pick the questions they'll ask to get you to that point, and as far as the explanation is concerned. But I'll let Mr. Diamond re-ask the question, and then please try to just answer the question, and we'll take it from there, ma'am. Thank you.
Okay. So we can get into the details maybe in a few minutes, but do I have the big picture correct?
Yes, that's correct.
Okay. And so my understanding, you're asking the court to reset the child support at $497 a month. Is that correct? And that gives, well, it's guideline minus the credit, which would be $497 would be the difference. Is that what you're asking the court for?
Yes, that is correct.
Okay. And in my understanding, you're asking the court to go back to the date of service on this?
That is correct.
Okay. And I think there was some.
Go ahead, Mr. Diamond. I'm going to look at the old order. Thank you. Go ahead, proceed.
Thank you, Your Honor. So, I show, and I think we're going to probably disagree on this one, Ms. Johnson. I show that Mr. Bourgeois was served on October the 15th. So typically, I think what the court will usually do is start the month after service, which would be November 1. So are you asking the court to restart the child support November 1, well, to modify the child support November 1, or are you asking the court to go further back than that?
Well, during this time, I've been conversing with Robin Connors, and she did suggest that I should ask the courts to retroactively have the non-custodial parent pay from the date that the payment stopped. She said that would be highly unlikely, but that I could ask the courts if the non-custodial parent could retroactively pay from the date of service, and that would be at the judge's discretion.
Okay. But that is your request. You're asking the court to go back to, I guess it was June when the child support started?
Well, the income withholding order was terminated on July 8th. I did get the payment for June. Therefore, the payment stopped in July. But I'm very aware that the order was reduced down to 0. Therefore, technically, he's not out of compliance through the Office of the Attorney General. So whether it's date back to July or to the date of service, whichever the court decides to do.
Okay. And then my understanding, I think the last time we did an order, you were willing to allow the court to deviate. Well, I mean, the court can do whatever the court wants, but you had no objection to the court deviating down $60 a month because Mr. Bourgeois was paying for haircuts.
I just wanted to, yeah, I mean, I'm a very compromising person, but this ordeal, I do no longer want to deviate that $60. First of all, the $800 is inflated. Our son maybe gets 2 haircuts a month. That's $20 a piece. But I did not want to push this out any further. So yeah, I was willing to deviate that $60 from the child support guideline of $1,410.
Okay. Okay. So, and again, I a few minutes ago, I asked, big picture we had right. There were some details that needed to be cleared up. What are those details that need to be cleared up?
Well, the details were, so when we spoke in May, right, we agreed to leave the original order as it was. My understanding was because the 437, since its origination in 2019, had always been going through the state disbursement unit. I didn't, obviously I didn't think that it would be dropped down to $0. Otherwise, I probably, well, actually, I didn't read it either. So it's, I don't really know what to say because I should have read it properly and I would have noticed that the amount was dropped down to 0, but there was never a direct allotment. And I feel like if I have access to the Office of the Attorney General website, I have an account, I'm able to pull up my financial activity. And in that financial activity, it does like, it's a clear, breakdown of amount paid, amount collected, and from what date it started. So I'm really just completely bewildered as to how this even happened in the first place. But yeah, just want to get things back on track.
All right, Mr. Donovan, I'm not seeing anywhere here where this thing was reduced down to 0. I see where he was given credit for what it was alleged that was coming from DFAS and going to her directly, but the amount of child support is clear in the order, and it was given credit for his SSDI that was coming to the child and the money that DFAS was sending to her. It's a credit. It's not it doesn't take it down to 0. Is there someone here that took the child support down to 0, Mr. Donovan?
Yes. Okay, sorry.
Where, ma'am?
Am I supposed to answer, or is that?
I'm asking the lawyer, but if you know where it is.
Your Honor, under the current child support, it's the order is for $0 beginning June 1, 2024.
Where's that, please?
Your Honor, it is. I'm sorry that I failed to number the pages in this order, but it's going to be page 10, Your Honor.
All right, then I see what you're talking about. Now, I don't think this is a motion to modify. I think this is a motion to clarify. Page 10 is incorrect. The order itself, back when you're actually doing the calculations, show exactly what the child support amount should be, and that given credit. When you made that change, when it went down, when you now changed it from say actual child support is 0, that was obviously incorrect, because in the prior section of the order, you showed it was supposed to be 1,400 and some change. You gave her credit gave him credit, extra 60. And I really don't think it's a modification. I think it's more of a clarification. And the clarification would be that, that page, the order 0 child support is totally incorrect. And that the correction should be to the original amount set forth in that order. If she's not getting that from DFAS, then obviously he's technically responsible for it. But folks, again, I'm gonna hate to punt this on you guys, but I'm thinking this is not a modification, sir, but more of a motion for clarification. So, that's what I'm thinking, but this doesn't come up too often. So,
I guess I'm a little hesitant to debate the law with someone with the court's experience.
Once again, your order's in conflict with itself, Mr. Donovan. That's the problem. It says something on one page, and then then does something totally different on the next page. It should obviously it should have said that the amount of child support was ordered based on that $400 difference, that difference between what the child was getting directly in SSDI and what y'all thought she was getting, so it still should be in there. But again, it's there in the order, sir, saying that that amount is owed. So the order is in conflict. So the court, again, a clarification would appear to be would be the better alternative. And I'm trying to think of would a clarification be that had to be done within 30 days or not. So anyway,
so
again,
actually, may I respond? Yeah, thank you, Your Honor. So I guess what I would suggest is that, and that's all this is a suggestion, but the guideline findings page, which again, I'm sorry, this is not ordered, but it'd be page 4. It basically, I would argue that it spells out why we're the support that's actually going to be assessed as 0, because it's 913 is the credit for his disability. 437 is the Army retirement that the state incorrectly thought was getting paid directly to Miss Johnson, and then 60 it was her, giving him a break. So I would suggest, and not argue, but suggest that that paragraph spells out, why the current support is set at 0.
That's what I'm thinking. That's what I'm saying, sir. That's why I think it's more of a clarification than a modification. But still, I'm not sure if I can do a clarification with outside the 30 days either. But I'm thinking I can. But again, this I don't remember this happening in the 20 years I've been doing this. So I'd have to look that up also. But obviously, your order is in conflict with itself. So that's what I'm looking at.
I guess the question, and it's a somewhat argumentative question, Your Honor, but assuming the state had it correctly that she was getting $437 directly from the Department of Defense, I don't know how else I would have written that up, because if she was getting the 437 along with the 913 for his disability, and if she was willing to agree to deviate down $60, I guess that's the way I would have written this order up, if at least that's how it would have occurred to me. Now, maybe
forward, sir, don't do that going forward. So if that ever comes up in the future, you still need to delineate what the correct amount of child support should be, because again, I'm not sure the circumstances how that was coming directly to her without a court order. So but again, so I always put that in there, that's the amount that's actually owed and due and owed going forward. But for right now, I'm trying to figure out whether or not how this should be handled, and I'm not sure if the modification is the correct way to do it. So, but I'll go ahead and let you proceed on this. Let's finish getting the testimony, and we'll figure it out. Thank you.
So Ms. Johnson, I'm about to ask Mr. Bourgeois some questions. Is there anything else that you'd like to tell the judge that I haven't asked you? Okay.
Yes,
all right. Thank you, ma'am. I'll pass the witness, Your Honor.
All right, then, ma'am. I'll be back in just a moment. Go ahead and call your next witness, please.
Okay. I call Mr. Bourgeois. Sir, will you state your full name, please?
Frederick James Bourgeois III.
Okay. And so, Mr. Bourgeois, my understanding is you feel that based on the circumstances that the guideline, in order for that guideline amount, which would be it would be $497 after the credit, you believe that that's not appropriate. Do I understand you correctly?
Yes, sir.
Okay, so can you go ahead and tell the court why you don't believe that's appropriate?
With the what I do for my son, with the activities and just my whole treatment process that's been going on, it's been great to be able to buy him more necessary things for my household, because he has his own room here, and he's inside my horse club, and I'm able to do just so much more with him. You can actually check my Facebook, social media, and things like that. And it's been great. If we are able to deviate just a little amount, where I can use that to do more activities with my son, it'd be great. Um,
Okay.
I was running a business at one. Yeah.
Go ahead, sir.
I was running a business at one time, and a couple of fellows fell sick on me, so I had to stop running that business. But I was really disturbed with the courts that they had me making $50,000 a year. This business was really voluntary, and it just really just helped veterans stay active, and now I'm at the point where I'm dealing with my own health issues with some stuff that they say came from burn pits in Iraq. And, I'm on a fixed income, I'm on a fixed income. And, that 497 or 437 that I was able to return with my son and then take care of myself. It really helped in the household.
So let me ask you a couple of questions along the lines of both. So how often do you get to see your son?
Pretty much every day. I go to school. Maria doesn't.
Stop that.
Maria.
Ma'am, you wouldn't
Maria
doesn't. In my courtroom, you don't do it on Zoom. Understood? All right.
Say that again.
I was talking to Ms. Johnson. You may proceed, sir.
Okay. Yeah. Maria, she doesn't hesitate to not let me see my son, but I've been going through her mother for the last couple of months since the payment stopped. It's been different. The video calls don't come no more, and I just take time and have lunch with him at school.
So let me jump in here real quick. So, but before the tension that was created by obviously my mistake, let's just call it what it is. How often were you seeing your son?
Oh shoot! Pretty much just whenever. Pretty much whenever. I call Maria up and I'll pick him up, and we literally stayed down the street from each other. So, and then I was able to put him in preschool early behind my military status. So that was great because they gave her a break from daycare fees.
Okay, so what I'm getting at, you were seeing your son more than every other weekend?
Yes, but when this happened, things changed.
Okay.
Right.
Your Honor, did the court want some questions about the health conditions of Mr. Bourgeois?
I'm going to have to reset this one. I got to do some legal research on this. Right now, I did a quick perusal of motion to clarify, and obviously I have the absolute right to clarify any order that is based on this information is non-enforceable. This appears to be such an order, sir, based on child support going down to zero. I don't think I can enforce zero child support ever. So I got a non-enforceable order. And again, we can argue this thing for another hour and a half. I just don't have the time today. So I'm looking at going ahead and resetting this for a special setting. And let's see about, I'll let you do your research. And again, I'm looking at saying this is on my own motion, looking at a clarification instead of a modification and taking it from there. Because again, right, I'm thinking this is what this is, but I rarely get motions to clarify. So I've seen what the code says, but I haven't had a chance to look at any case law. So I'm looking at looking at the case law on this one, and I hate to do this like this, but I'm probably thinking about putting these folks back on the docket for next week where we can get this done before the end of the year. So I know I got a couple other dockets coming up, but this one's a little bit more complicated than I anticipated, and I need my chance to do the opportunity and to look at whether or not the order itself is should be clarified instead of modified, and actually let these folks, if they want to get opportunity to talk to a lawyer instead of me doing this super fast, making them instead making them come back after the first year in one of our early dockets next month, to give them the opportunity to talk to their own counsel on this and give the state the time to do its own research also. So I'm thinking that might be the better way, because it's not going to change anything that much. So
Thank you, Judge.
But
Your Honor, my request would be that it not be on Monday, if we could get in one of those other days. The docket on the 18th, it's an in-person docket, but I know there's one afternoon case. Maybe we fit this one in before then, if that works for the parties.
Yeah, that works great, because on Mondays I do mental Mondays and I just be at the ranch. So that'd be great.
Let me get back to my calendar here.
I have a question.
Yes, ma'am.
Am I considering Mr. Bourgeois brought up the visitation and access and stuff, I would like to know if would I be able to submit calendars from?
Ma'am, okay, again, that's strictly for him to modify the child support to deviate from guidelines. And right now, I usually don't do that, but yeah, you can bring anything you want to counter, but right now it's just to see if the court's going to grant a deviation from guideline child support.
Well, I understand, but the court allowed him to speak on visitation and access. I have been asking his school teacher to keep track of who's been signing out our son from school. And you know, he doesn't help. He doesn't sign them out on Thursdays or on the 1st, 3rd, and 5th. So everything that he's saying with regards to his frequency of spending time with our son is not true. So, you know, and this is very frustrating situation because I knew he'd bring that up.
Okay, here's the deal, man. I don't deviate. All right. I've got to have, you heard my morning speech. I only deviate there's a legal reason. He's giving me testimony that he's doing all this extra stuff. But again, the guidelines are the guidelines, and I order guideline child support unless there's something out of the ordinary. All parents to see their kids, all parents take the kids out to movies and dinner and all those things that come out of pocket. It's part of being a parent. So, you know, it doesn't sway me that much. But, and again, unless, and if you've heard, I just don't deviate from guideline child support because the legislature took into consideration what the extra expenses or what the other parties should be doing for their child. So unless there's something out of the ordinary that he's doing something special, like one of my kids used to take horse riding lessons that ran, a few hundred a month and stuff like that, then yeah. But other than that, I hadn't heard that. So again, I understand what he's asking for, but I'm not looking at deviating at this point. But again, I'm trying to figure out how the heck I'm gonna get back from point A to point B, and we're not gonna do it today, ma'am. So if y'all
understand.
So if y'all want to come up with something different, or y'all want to have something
else
to say,
I have a question.
Stop, ma'am. I can't. Again, I'm getting ready to stop this hearing. This one went on way too long. I almost didn't start it because I figured it was going to be like this. So we're going to save this one. All right. Thank you. Anyway, all right, guys. Here's the deal. I got a general Zoom docket next Monday on the 16th. Belinda, is that right?
It is, Your Honor.
And I've got a general one. Let's pause. Okay.
Mondays is the only Zoom next week, Your Honor. Wednesday is an in-person, but there's a Zoom in the afternoon. Actually, I don't even know that it's a Zoom in the afternoon. It might be an in-person.
All right, folks. Again, I'm looking at doing this one on the 16th, at least as a temporary order, guys, and then figure out how do my own legal research and see how I'm going to try to handle this. I'm going to go ahead and reset this matter to Monday the 16th at 9 a.m. And I'm looking at doing at least a temporary order, ma'am and sir. They'll get us until next year before I can figure out how I'm going to specifically handle this. But again, I know there's a lot of legal mumbo jumbo. The difference between a clarification and a modification, yeah, but there is a legal difference, all right? And that's what I'm looking at. And folks, I'm sorry, but this one has taken up way too much time. I wasn't going to do any 30-minute hearings, and this one's already got 35. So, we're set to 9 a.m. On the Zoom docket. You'll get that information, and we'll take it from there. But then by then, I can have some time to look up the whether or not I need to do a clarification or a modification, and set it up as a final or attempt. But I'm probably looking at only doing a temp, because you're technically both entitled to more time to consider a clarification, and I don't want to interfere with your legal rights as far as the time frames the court that you're allowed under the Texas Rules of Civil Procedure. So again, apologies, guys, but this one's reset to 9 a.m. On December the 16th. And obviously we can take this one up first, Mr. Diamond, as soon as I don't have anything at 9:30, at 10:30. So as soon as I move from the chambers to the courtroom, we can start this one at 10 a.m., 10:15 sharp. All right.
Yes, Your Honor.
All right. Sorry, guys. Anyway.
Thank you.
Well, thank you, Mr. Diamond, Judge Nelson.
All right, then I'll see you guys on Monday, and let's see what I can find out. Thank you. We're off the record.
Thank you, Your Honor.
As I recall, Mr. Diamond, this is the one where there's the modification, but court was feeling like it's more, well, I guess a modification can be a clarification too, but I felt like it was more of a clarification circumstance, right?
That's my understanding, Your Honor.
Okay, well, like I said, I get, you could modify and clarify at the same time, so that's not a major problem. So let's go ahead and see what we've got here. All right, here we go. So at this time, the court's going to go ahead and put on the record Bell County calls number 310,263-E. This is in the interest of Bourgeois, a minor child, non-custodial party being Frederick Bourgeois, custodial party being Maria Johnson. This matter is before the court on super modification of child support. Both parties have probably been noticed and served in this matter. This court reset this matter to today's date to have more time. Anyway, the court will note that both Mr. Bourgeois and Ms. Johnson are present. The state is present. And if I recall correctly, and I'll need the state to remind me on certain aspects of this case, but thinking that the child is getting some SSDI payments from the federal government based on Mr. Bourgeois' disability, and that the court the court will have to give him credit for if that's the circumstance. But anyway, I'll let the state remind the court and tell the court at this time what the state's requesting we do here today, whether or not they're requesting this to be a final or temporary order, sir. Thank you.
Your Honor, so would love a final. The parties would have to consent to that because we've only got 6 days since the last time we were before the court. But great if the parties are. At least that's my understanding. If the court has another method of getting a final order, then the state has no objection. But that is correct. So the reason we filed this, and this was my misunderstanding, Mr. Bourgeois has income from several sources. So one of them is. And I'm sorry, I'm pulling my docket notes. It's 900 something from I believe it's 900 something from oh God, where are my notes? It's 900 something from one source. It's similarly 4 something from another, and I'm having a hard time pulling up my notes. But the issue that we ran into was the state mistakenly thought that the payments were direct from both of the sources. The second source for 4 something is I think it's like Army retirement or something along those lines.
It's combat disability, Mr.
Combat disability. Sorry about that, Mr. Bourgeois.
Yes.
And I'm not trying to slight you. Anyway, so the state mistakenly thought that both were getting paid directly to Miss Johnson. They're not. The bigger 900, I think it's 911, and that probably is from SSDI. It is direct benefits, but the rest is not. So the last time around, the court found that the guideline child support that was $1,400, I believe, $11 or $10. But the way that the order was drafted had it as the monthly child support payment was $0 because. Well, mostly because I was giving Mr. Bourgeois incorrectly a credit for that 4 something, and then Miss Johnson was also willing to give him a $60 credit because he had been taking care of haircuts for their child. So, and again, I'm sorry that I don't have the exact dollar figures, but I'll get those in a minute. Anyway, but the state's request is that the $900, I think it's $911 credit remain, but that Mr. Bourgeois be ordered to pay the difference. My understanding, Ms. Johnson is no longer willing to give him credit for the haircuts. I realize that the dollar figures were off in my opening statement, but did I get the general idea correct with my opening?
You did.
Okay, so I think the correct dollar figures are you receive $913 a month in direct benefits for through the Social Security Administration. Is that correct?
Yes.
I should say the child receives it, but it's sent to you.
That is
Okay.
correct.
Yes, ma'am. And then I think you were getting $437 from the Department of Defense. Is that correct?
No, I never got it directly from the Department of Defense.
Right.
It always came through the disbursement unit.
Right. So that's really what I was asking. So I mistakenly thought that was being paid directly to you. Is that correct?
That's correct.
All right. So the $913 is the only thing that you're getting paid directly.
That's correct.
All right. And then my understanding is that previously you've been willing to give Mr. Bourgeois a $60 credit because he'd been taking care of haircuts. Did I understand correctly back then?
Sure.
And then, but do I understand correctly now that you're no longer willing to give him that credit?
That's correct.
Okay. And then I believe that to finish the story, $1,410 would have been the guideline child support. Is that correct?
Yes.
All right. So, Your Honor, I realize you can do math, but if I can just put it out there. So $1,410 was the guideline calculation minus 913. So $497. That's the difference that you're requesting the court order, Mr. Bourgeois, to make up.
That's correct.
Okay. I'll pass the witness, Your Honor.
All right, ma'am. Okay, the court needs something here. You were getting the money through the state disbursement unit, the $400, or is that correct?
Yes, sir. I've been getting it since November 2019.
All right, and that's based on his combat disability, so forth and so on, but you're still getting the funds.
No, I'm not.
Okay, when did that stop?
July 8th.
And do you know why?
Yes.
Okay,
Because the guideline was set to $0.
May I jump in, Your Honor?
okay, that's this case, right? Okay. All right, now and do you know where the $400 is going right now?
I'm unaware of that information.
All right, well, we'll get that from Mr. Bourgeois in just a moment to see if he's getting that back or if it's sitting out in limbo somewhere. Or if we'll get that testimony from him in just a moment. Thank you, ma'am. You may proceed, Mr. Diamond.
Your Honor, if I could proffer something, this would go a lot faster. And I realized my opening was lousy, and I wouldn't be having to do that if my opening hadn't been so lousy. But if I could proffer, so basically what happened was there had been withholding because of the order that was drafted by me. The withholding stopped because the order indicated that there was these direct payments, and so the monthly payment after giving credit was $0. So the DFAS was directed by my agency to quit withholding. I mean, I guess we don't direct, we requested that they stop the withholding because we thought that we were getting what we were supposed to be getting.
So that wasn't an automatic payment that she got under, or the child was getting under that, right? It was just something that the AG did as far as getting wage withholding for the child support, and it was coming through the state disbursement unit, and then you were giving credit for that. Direct credit payments from him when it really just was y'all's withholding order, correct, sir?
Yes, sir. And that's my misunderstanding, Your Honor.
That's okay. Well, like I say, we'll get a new withholding order to get everything set back up properly. All right. Just want to make sure that somehow mom wasn't getting some type of allotment or automatic payment or something along those lines. Thank you. All right, let's confirm that information with the father, and you can proceed in either with Ms. Johnson or call your next witness, please.
So, Ms. Johnson, you heard what I just told the court. Does that sound correct to you?
Yes, sir.
Okay, thank you, ma'am. I'll pass the witness, Your Honor.
All right, be back to you in a moment, ma'am. Thank you. Call your next witness then, Mr. Diamond.
Okay, I'll call Mr. Bourgeois. Mr. Bourgeois, you've heard what I told the court today. Does anything sound incorrect there?
Negative.
Okay, and I should have told the court that I think part of your request is, and wasn't trying to give you short shrift on this one. You're asking the court to consider some other factors and possibly deviating below the guideline. Is that correct?
Correct, okay. Mr. Diamond.
And again, Your Honor, I'm sorry I didn't raise this in the opening a minute ago. Mr. Bourgeois, so can you tell the court the factors you're asking to be considered as far as the downward deviation?
Right now, I'm on a fixed income. I've been having some medical issues the past year, and I take care of my son more than often, spending more time with him throughout the years. Never missed a payment, and just trying to just take care of my health at this time frame. And the fixed income is standard. I'm using a lot of those funds to do more with my son, as far as like activities with horse therapy, being out in nature, being with the school more, and just what a father's supposed to be. And I just asked the court that that my combat disability pay be used for my medical reasons and other outside activities to help me with my therapy.
Okay. And I think that you had told the court previously, I think the last time we were here, that you had been seeing your son more than the standard possession order until recently. Is that correct?
Correct. So once the order was changed, and my ex-wife, she stopped videoing me. I had to really go to the school more often to just see my son. And we really didn't go by the guidelines as far as like standard custody. I was able to pick him up when I wanted to. We literally stayed 3-4 blocks down the street. But once the money was caught short, and I have emails and paperwork and whatnot that actually states that what she was saying was that, until the money is back on track, then, the way that I'm not going to video you, I'm not going to do this, and I'm not going to do that. And it was, I never thought that it'll actually be about the money as far as me spending time with my son,
And
But-
I apologize that my mistake caused you to lose time with your son. Before this whole thing, so before May of this year, how many times a week were you seeing your son?
I mean, I go a couple of times to go have lunch with him. I call him up, I call Maria up, I'll be able to pick him up from the house. And now, with the fact that I wasn't able to video him the last months, or just like us being practical like we used to be, her mother stepped in, and, me and her actually started having time frames and whatnot. I told her like Tuesdays and Thursdays, I able to pick them up from school, drop them back off and whatnot. I wasn't able to do that the past month because my brother has been in stage 4 in the hospital. But, me and her mother has been very applicable as far as like with Frederick, as far as just me spending time with him and whatnot. She don't have no type of hiccups with it, no type of hiccups. But
Okay.
I haven't videoed my son in months. We only communicated by email, and it was just, I mean, it brought me to a down spiral to a degree,
Yes, sir. And the horse therapy, is that for you? Is that for your son? Is that for both of you?
That's for both of us. I was actually able to get his RV, which he'd been talking about for months because a tornado had messed up our RV about a year or so ago that hit Fort Hood, Texas. So the mildew between the RV, he wasn't able to, they labeled it a loss because I had a small child. So we, found an RV with bunk beds. He's always in the country. If you look at my Facebook post, you will see him ride horses out in the country. I mean, pretty much a few times out the week, it's literally down the street from my house. And, it does justice with his social skills. Other kids be out there learning, just not being in the room on Nintendo games, just that old school father-son relationship. So.
Yes, sir. And then I guess the question I have, I don't, and the court will probably correct me if I'm wrong here. I don't know that. So would you be okay if the court did a final order today? I think you have the right to ask that this only be a temporary order. But if, assuming I'm correct, would you be okay doing a final order today so we don't have to keep coming back?
This is taking a toll on me, Mr. Diamond. So I'm just ready to get this done with. You know, I'm just ready to get this done with.
Yes, sir. And I apologize for my part in the toll on you. I'll pass the witness, Your Honor.
All right, Mr. Bourgeois, you're getting you're 100% disabled from the VA.
Roger,
Okay.
George.
So you're getting a slightly above $4K a month for that. Is that correct?
I think so.
All right, and you're getting also Social Security disability.
Yes, sir.
How much you get on that one, sir?
I think Mr. Burnham has the numbers. I think Ms. Diamond has the numbers. I think it's like 1380 or something like that.
Right. That's what I think. I thought about 15, but yeah, you know, it varies. So. All right, and those are your only two sources. Is that correct, sir?
I receive combat disability.
Okay, that's not included in the VA. Okay, and what's that amount?
I have to actually look at that.
Again, sir, yeah. So I just know what your sources of income are, and I understand your circumstances. So,
Okay.
anyway, I'll let you say any other questions of this witness, Mr. Diamond?
No, Your Honor.
All right, you need to call Ms. Johnson to recall.
Yes, please. One question, Your Honor.
All right, thank you. What's the question of Ms. Johnson?
Ms. Johnson, would you be in agreement with doing a final order today?
Yes, I will.
Okay, thank you, ma'am. Nothing else, Your Honor.
All right, folks, I understand, you know, money's tight. That's just the way households are. I mean, if you made $10,000 a month take home, you'd still be tight. You know, that's just the way it works. But Mr. Bourgeois, I got to look at it. I look at this both ways. I understand that this has affected you, but this obviously affected the mom. She was getting the entire amount, you know, at one time. She was getting the disability and the $400, and now she's getting $400 less a month. And yeah, but it's, you know, it is what it is. It's kind of unfair. But I don't see a way to take that away, sir. That's the amount you're supposed to pay in child support. That's what I got to look at paying. So obviously I got to, so I got to go with that one, sir. Hopefully you and she can start, you know, working things out again. But right now, the only thing I can deal with based on the motion that's before the court, even if it was a clarification and not a modification, the only thing I can deal with is the child support amount, and that's the amount under the law she's entitled to, and that's what the court, based on the current circumstances, are in the best interest of the child, sir. So, Mr. Diamond, I'm looking at obviously giving Dad credit for the disability that she's getting based on his Social Security disability. Well, I'm looking at ordering the $497 a month child support difference to be paid by Mr. Bourgeois. It's the math. I hate to keep saying that, but it's you know, I'm a finance guy, and you know, the math's always the math, sir. And again, I wish there was more money, but based on these circumstances, if I give it to you, I got to take it from her, and I really literally mean take it from her. So I just can't, based on these circumstances, sir, I just can't do that. So anyway, I'm gonna go ahead and grant the modification. Well, it's actually a modification / clarification. The order itself put down the amount of child support, but obviously it just didn't. When it stopped coming to mom, there was no longer a payment coming. So I'm going to order that the difference between the two in child support be ordered to pay. I'll start that. However it works with your system, Mr. Diamond, you can start the first day of this month or the first day of next month, as far as the amount of repayments being concerned. And for the difference between what child support would be without her getting a disability, and everything else is again, I was looking over the motion itself, and the only thing in the motion I can deal with is this money, so that's it. So that's all I can deal with, and of course waive court costs due to military service.
Your Honor, I understand the meat of it, but the title of the order, You want this as a order clarifying, order?
No, you filed a motion to modify, so I want you to call it a order modifying, but put it in there. This modification order is a clarification of the prior order, okay? So that's what it really is. The prior order was correct, it just wasn't implemented correctly.
Yes, Your Honor. And again, I apologize to Ms. Johnson for the financial hardship, and to Mr. Bourgeois that you didn't get to see your son normally because of this. And we'll try not to make this mistake again.
All right, folks, again, hopefully y'all can, this won't cause too much of a rift, but again, the courts, if this case came before every court in Texas today, 99% of the time it would end up the same way. It's just, again, it's the financial mathematics of the circumstances, and the court, like I say, will go ahead and grant the child support based on the facts are in this matter. Thank you. Is there anything else at this time? Any questions, Ms. Johnson? Anything else, ma'am?
No, sir, thank you.
All right, Mr. Bourgeois, questions, sir?
Negative, Honor.
All right, good luck to both of you folks. I hope you have a Merry Christmas. Well, what's he gonna be, 5 this year?
No, it's gonna be 6 next year.
6 next year. Okay, well, he's got this Santa thing down pat, right? Good luck with those. Good luck with Santa giving him everything he needs. All right, so everybody be out there and take care, because it's a crazy, crazy world. Drones and weirdness all over the place.
You're right.
So take care.
You're right. You're right.
All right, thank you, folks. And Mr. Diamond's going to prepare that order and circulate it. And again, signing off on it doesn't mean you agree with it. It just means this is what the court ordered, and eventually come to me anyway for signature, and I'll take care of it no matter what. All right. Thank you, folks, and we're off the record.
Thank you, Your Honor.
Mr. Diamond.
Sir.
Could I? Is it just me and you online right now?
No. If
You're
you want
the
to
man
visit, I'll
doing
put
it.
you in a breakout room.
Okay.
Thank you.
Well, I want to be in a breakout room too,
Yes, ma'am.
All right.
because I do have a question.
Yes, ma'am. Not a
Problem.
problem.
Not a problem. We'll take care of you.
So, considering,
Let me, ma'am. I don't want to.
No worries.
We have to broadcast, and I don't want your business going
Right
out
now,
over the
you're on
internet.
YouTube, ma'am, and probably got about 300-400 people looking at you. So yeah, you need to get back in the breakout room. All right. Thank you.
sir, no problem.
Thank you.